My name's Jay McDaniel, and you're listening to Closely Held. One of the first obstacles that a company will encounter when it's trying to protect its rights to confidential or proprietary information is whether the information is a trade secret in the first instance. And this is a threshold issue determined by the conduct of the party claiming the secret as much as by the sensitivity of the information. If the information is in the public domain, or if the owner of the information has not taken steps to protect it from disclosure, then under New Jersey law, there is no trade secret to protect. That was the result in this case from New Jersey Superior Court that we're going to talk about today. Please take a moment to subscribe to this video podcast if you find the information useful and share it with others. We're going to look today at the elements of a trade secret claim in New Jersey, both under the common law, which is judge-made law, and a state statute, and consider why the plaintiff in this case was unable to protect what it claimed was a secret formula. In a New Jersey lawsuit brought by a beauty supplier, trial judge here in the Superior Court dismissed claims asserting that a competitor had misappropriated its trade secrets and that its former employees were in breach of the confidentiality and non-solicitation provisions of restrictive covenants. The case was Eben New York, Inc. versus Beauty Plus Trading Company, Inc. It involved the formula for an adhesive hairspray. The plaintiff sued its contract manufacturer and Beauty Plus, a competitor, along with individual defendants that it claimed were bound by agreements that they had made as employees that prohibited competition or disclosure of confidential information. The case provides a good framework to analyze a claim alleging misappropriation of a trade secret under New Jersey law. It's also a cautionary tale to a company that relies on the secrecy of its proprietary information. The value of that information can easily be lost if the steps to keep it secret are not in place. The plaintiff claimed that its contract manufacturer had signed a confidentiality agreement in September of 2021 before it began to produce the adhesive hairspray. The court dismissed the trade secrets claims, however, at the pleading stage because of the plaintiff's failure to establish the existence of a protected trade secret. In New Jersey, as in many states, misappropriation of trade secrets claims may be pursued under either the common law or under the Uniform Trade Secrets Act. For a claim for a trade secret to succeed under the common law, the trade secret owner has to establish certain elements. Those elements, which we've got up here, to succeed, the trade secret owner must establish that. First, a trade secret exists. Second, the information comprising the trade secret was communicated in confidence by the plaintiff to an employee. And three, the secret information was disclosed in breach of that confidence. The owner of the trade secret also has to show that this secret information was acquired by a competitor with knowledge of the employee's breach of confidence, that the secret information was used by the competitor to the detriment of plaintiff, and that the plaintiff took precautions to maintain the secrecy of the trade secret. In this case is a well-known decision of the appellate division of New Jersey Superior Court, Reicheline Products versus Walsh. New Jersey courts determine whether the information is actually a trade secret by considering 6 factors. These 6 factors under New Jersey law are the extent to which the information is known outside of the business, the extent to which it's known by the business's employees and others who are involved in the business, the extent of measures that are taken by the owner to guard the secrecy of the information, the value of the information to the business and its competitors, the amount of effort or money expended in developing the information, and the ease or difficulty with which the information could be properly acquired or duplicated by others. And here again, we're relying on a case from New Jersey from the appellate division. It's Samsung Electronics versus West Park Electronics. So as you can see, there's a number of elements that are necessary to establish the existence of a trade secret and that there has been a misappropriation of a trade secret. Proof of the existence and misappropriation of a trade secret is much more straightforward when a plaintiff relies on statutory protections, in particular, the protections that are available under the New Jersey Trade Secrets Act. It's a version of the Uniform Trade Secret Act that was adopted in New Jersey by the legislature in 2012. Here, the test for the existence of a trade secret is embodied in a relatively simple definition. The statute defines a trade secret as information it's held by one or more people without regard to form, and that includes pattern, business, data compilation, program, device, method, technique, design, diagram, drawing, invention, plan, procedure, prototype, or process that, first of all, derives independent economic value, either actual or potential, from not being generally known and not being readily ascertainable by proper means by third parties who can obtain economic value from this disclosure. And two, is the subject of efforts that are reasonable under the circumstances to maintain its privacy. In this case, the court first rejected the claim that the identity of the supplier, as claimed by the plaintiff, was a trade secret. Prior courts have ruled that suppliers' identities are not in themselves a trade secret, at least when there are alternative suppliers that are readily identifiable and available. Here, the supplier was identified in the complaint, and there was no evidence that it was not actively promoting itself as a supplier to the beauty industry. So the identity of supplier was generally known, and the services that it offered were generally known. In a similar manner, the court rejected the claim that the formula for the product was a trade secret because it was known to others. Plaintiff had developed the formula and then disclosed it to other manufacturers before it chose the defendant manufacturer. So it had shopped the jobs, including the formula, to various manufacturers. The court also rejected the claim that the plaintiff had taken reasonable steps to protect the confidentiality of the information. Plaintiff relied on a manufacturing agreement as proof of the steps that it had taken, but that agreement had been put in place shortly before the dispute at the heart of the case had developed. And the court said that did not cure disclosures that were made earlier. The lessons here in this case are pretty straightforward. Confidential information must be protected. Anytime it is disclosed outside the company, there must be an agreement in place that maintains the secrecy of that information. This includes discussions with vendors and also includes documents filed in court. Company's failure to keep its information secret cannot be cured by non-disclosure agreements. If the information is in the public domain, the prohibition against disclosure and use will simply not be enforceable. Here, the fact that the former employees were bound by prior agreements meant nothing, even when they predated the disclosure, because the company had since permitted the information to become public. Thanks again for listening. Feel free to contact us if you have any questions on a trade secret dispute or need guidance protecting your company's trade secrets against misappropriation. Don't forget to subscribe and interact with us by liking or sharing this program. Thanks again.